good morning, everybody. My name is Julie Bowers, and I am the Director of the Office of Inclusive Education at the Nevada Department of Education. And we're excited to spend the next hour with you just talking about what our office is, who we serve, and the work that we do. I am joined by my colleague, CJ Fields, who is Assistant Director in our office. And I'm just going to give you a little bit of background about myself, and then I'm going to let CJ introduce himself, and then we'll get right into our presentation. So again, I am the director of the office. I have been with the Nevada Department of Education for 8 years this month, and this week I formally completed my first year as director. So I'm very excited to have reached that 1 year mark in this position. Before becoming director, I was also the assistant director and an EPP in the office, or educational programs professional. And my areas, this is my 33rd year in special education, and my areas of focus have always been on our students with the most complex needs, as well as our students who are transitioning from our high schools to the world beyond. So that's a little bit about me. I'm going to let CJ tell you a little bit about himself, and then we'll go ahead and move on to the presentation.
Morning, everybody. My name is CJ Fields, and I am the Assistant Director of the Office of Inclusive Education, and actually have very similar background to Julie as it relates to working in the field of special education. Prior to becoming the assistant director, which I'm relatively new in this role, this is, I think, month 3 or 4. I was an EPP in the Office of Inclusive Education at the department, and my focus was on kids with the most significant needs statewide. I did a lot of our work around the alternative diploma in Nevada and post-secondary transition. And prior to that, I was a district-wide transition coordinator for students with disabilities in Lyon County, and prior to that was a high school teacher of students with severe cognitive disabilities. So we actually have some pretty similar backgrounds, and happy to be here today to talk to you guys about what the Office of Inclusive Education can offer families and districts as well.
All right. So to start the presentation, we really just wanted to let you know who lives, or so to speak, works in the Office of Inclusive Education, and knowing that we oversee 3 different programs: special education, gifted and talented education, as well as Indian education. And so we've, CJ and I have introduced ourselves. Catherine Fuselier, who is not with us today, but she works in our office. She is our Part B manager, Part B data manager, and she handles all of the data collections from the districts, as well as the data that we report to our federal partners. And you're going to learn more about that as we work through the presentation. But if you're district folk and you want to know more about where the data lives, Catherine would be the person that you would talk to. Jennifer Kane, who is located in our Las Vegas office, is her primary focus is on secondary transition, and she provides technical assistance and training to school districts on meeting our indicator 13, or our transition goals within our monitoring system, as well as working with our external agency partners such as VR and the regional centers to ensure that all of our students have plans for meaningful transition from secondary school. Andrew Morgan is also in our Southern office. He is a special education compliance EPP, and he also monitors and works with our GATE program. So our GATE program, a little bit different from everything that we do in special ed, but it's to ensure that all the students who are eligible to receive GATE services have access to an endorsed GATE teacher. And so we do monitor districts for that. We currently have about 8,500 gifted and talented students throughout the state of Nevada. Austin Olson is in our Carson City or our northern office, and he works with some of our required reporting on data around behavior and discipline, as well as provides, again, technical assistance and support for districts, offering things like CPI or different types of training to help teachers manage classroom environments and student behavior. Ashley Price is our resource coordinator in our office and EPP with experience in autism. She is helping us set up and have our website and our resources readily available to both our district staff and teachers and administrators, as well as our parents, so that everybody can easily access the resources and information about our office online. We currently have an open position for an early childhood EPP. This person will oversee all things related to early childhood and our inclusive preschool programs. And we hope to name that person very soon. We're just finishing up the interview process and hope to have that position filled. Additionally, in our office, in our northern office, Ferdina Dry Romero is the EPP that oversees our Indian Ed program. And just a general view of our Indian Ed program, because we're not going to focus too much on it today, but I wanted to let you know that we oversee 3 major projects within that Indian Ed, besides providing technical assistance to our teachers, our Native American teachers in our tribal schools, public schools on reservations. But we oversee what we call the tribal consultation process. And this is a process to really facilitate conversations between school districts and tribal leaders on reservations with public schools to ensure that they are receiving the resources that the district, from the district, that is needed to improve those schools for and outcomes for those Native American students on the reservations. We also administer subgrants to tribal groups to improve outcomes for Native American and Indians and American Indian students through our Native Youth Community Project grant. And we have just finished one 5-year grant, and we're getting ready to start another one, and are very excited to provide resources for our tribal schools to improve graduation rates, as well as to improve sort of the transition process, similar to special ed, but different because it's not part of the IEP process, but to ensure that they're ready for college and career and the world beyond. We also are currently using our ESSER funds to create a curriculum enhancement project so that we have lesson plans available for all of our teachers throughout Nevada that are historically accurate and Nevada specific to the Native American history that exists here. So very important work going on in our office. We're going to talk a little bit more about some of our special ed work as we move forward. So I'm not going to spend too much time talking about those programs or those responsibilities right now. We're going to move into an overview sort of a special education law. And we really felt like this was important because our office, the work that we do is all in regard to IDEA, or the Individuals with Disabilities Education Act. So all of our responsibilities, all of our resources, all of our actions are meant to meet these goals set forth through IDEA. So just a little background: originally known as the Education for All Handicapped Children's Act in 1975, eventually became the Individuals with Disabilities Act in 1990. And one of the reasons for those changes, the language that we use. We don't tend to use those words anymore, but we use the words people first language with individuals with disabilities. And the 6 pillars of IDEA ensure that: 1, our public schools are required to create individualized education programs, or IEPs, for each student who is found eligible for special education services. And that the IEP must be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. And this is very important. This is the crux of our work. We work with our districts pretty specifically on ensuring that FAPE and the implementation of IEPs is happening throughout the school districts. The second one, to the maximum extent appropriate, IDEA ensures that all students are given the opportunity to learn in the least restrictive environment, or LRE, in an inclusive classroom environment in which students with disabilities can achieve the greatest level of academic success. And for those of you who may have been with us for a while or know us, our name changed from Special Education to Office of Inclusive Education about 4 years ago to really encompass this idea that all children, regardless of the programs that they need, are offered the opportunity to learn side by side with their peers in the least restrictive environment. And that is something that we are very focused on in our office. The IDEA entitles students with disabilities to a free, appropriate public education. Again, you've heard me say those words, or FAPE. A FAPE is an educational right that ensures educational programs and related services are designed to meet students with disabilities' individual needs as adequately as the needs of students without disabilities. So again, it is our responsibility to help districts ensure that all of our students receive that free, appropriate public education. And as we'll talk about in a little bit in the presentation, what to do when we feel like the district isn't doing that job. IDEA also includes a set of procedural safeguards designed to protect the rights of children with disabilities and their families, and to ensure that all students with disabilities receive FAPE. The safeguards include the opportunity for parents to review their child's full educational records, the rights of parents to request an independent evaluation, and more. So again, today, I don't know how many parents we have in the room or educators, because it's hard for me to tell based on the screen, but it's really important for parents to know what their rights are, especially in regard to the special ed processes that are available to them. And so if you have any questions about those, by the end of the presentation, hopefully you won't have any more questions, but if you still continue to, please reach out to us. IDEA ensures that the use of appropriate evaluation process. This minimizes the number of misidentifications, provides a variety of assessment tools and strategies, and prohibits the use of any single evaluation as the sole criterion, and provides protections against evaluation measures that are racially or culturally discriminatory. So again, it is our office's responsibility to ensure that the school districts are using an appropriate evaluation process, and that they're following the timelines that are required under IDEA to identify students who may be eligible for services, to identify them as eligible, and to put services into place, again, in a timely manner. And the last tenet of the IDEA is really cross-collaboration, which is key for each of our students to receive an education necessary for success. IDEA enables parents, teachers, school psychologists, and other relevant parties to work in tandem when developing IEPs, determining the proper least restrictive environment, and discussing other important considerations for the student. So we always encourage our parents and our school districts to work together to provide meaningful programs for our students with disabilities. And again, this is really outlined in that IDEA. Under IDEA as well is what we in our office call our components of general supervision. And these are the tenets that OSEP, our Office of Special Education Programs, has set forth for our Office of Inclusive Education, overseeing special education, is sort of the foundation for our work. And so everything that we do is in regard to one of these areas. and is interwoven within the work that we do in our office. So I'm just going to spend a little bit of time going over each of these areas because I think it's important that you see how we do our work in relationship to each of these. So the first tenet is fiscal management, and it is our state's responsibility to provide oversight in the distribution and use of funds according to federal and state requirements. And state must provide oversight with the use of these funds. So just a little bit of background for those of you who may not know, we get federal funds, which are considered and called Part B funds from the federal government for our special education programs each year. Those are presented are given to the Department of Education, and then we in turn subgrant those or award those funds based on a formula to the school districts. And so while we don't specifically direct how they use those funds, we ensure that they spend those funds in accordance with the law. So we and then we work with them to create programs that are fiscally sound and support our students with disabilities. Integrated monitoring is another one of the, is part of the work that we do in our office. And we do this across multiple projects, but effective monitoring strategies are integrated across all components of our general supervision. So most of you probably know that we monitor school districts, and we do what we call a file audit, where we look at IEPs to ensure that they're compliant with the law. But we also look at programming the use of fiscal funds and other things in our monitoring process to ensure that all the things at the school district are improving compliance, are compliant and improving results for our students. This includes on-site and off-site monitoring activities. So sometimes we meet with the school district in a certain place and review files, but we also really like to spend time in the district talking to the individuals that work with our students, as well as being able to see with our own eyes what's happening in the school. So we didn't get to do a lot of that over the past 3 years, and we're really excited that this spring we'll be able to take a little road trip around the state and do on-site monitoring in our rural districts this year. In sort of conjunction with monitoring, sustaining compliance and improvement is really the core of our work as well. So it's ensuring that correction and other things happen following a monitoring visit or in other areas where non-compliance has been found. And it includes our state authority to really enforce regulations and policies and procedures in the school. And we do that sort of by providing, we do that by providing technical assistance to our districts to help them correct areas of non-compliance and supporting them through creating a plan so that those non-compliance issues do not exist anymore. And so we do this through individual technical assistance with our districts. We do this through professional learning opportunities with our districts, but really it is our work to improve the base of compliance so that we can move beyond compliance to really improve our outcomes for our students. It is also our responsibility to ensure that all districts follow state and federal policies and procedures for effective implementation of practices that are aligned, again, with IDEA and our state statutes. We must have at the SEA level or the state education agency level descriptions of how we do things, right? Our processes and procedures. And again, we are working on, as I said, that resource as well to make our website stronger so that you know more about our work as we make sure that we're giving those descriptions and how we will use and then again, how we administer those policies and procedures how we work with our districts to detect noncompliance, either through our monitoring or other areas, and how we will ensure that correction of noncompliance. So it's sort of our authority to overview the programs and if there is something that's not happening in the programs, it is then our authority to help them again make those corrections. Probably the biggest area of our work is to provide technical assistance and professional development to our LEAs, as well as to our parent and stakeholder groups. This area of professional learning and technical assistance must be directly linked to our SPP, our state performance plan, and annual performance reporting indicators, and be centered around activities that will really improve results and compliance. And you'll start to see some of this starts to overlap a little bit, so you start to hear the same things again. But again, we have that authority to review our programs, and once we see things that might not be working, we really want to provide that technical assistance and professional development to help fix those problems. But moreover, we want to use our opportunities for technical assistance and professional development to move past those and to really implement new programs and special projects across the state that really work towards building the capacity of our teachers and our administrators across the state, and even our parents in their knowledge of our programming. But also our overall is to improve outcomes for our kids. And so we have several special projects that are happening throughout the state. We won't be able to talk a lot about them today, but hopefully we'll be able to share a few of the things that are happening throughout this. But it's really, again, around seeing the needs of our students and making sure that we can provide that technical assistance. It also means that we as a staff also engage in professional learning and continue to learn across that area. And we use a lot of our national technical assistance centers so that we can make sure to stay up on things that are happening and keep educating ourselves as to how to do our work better in the state. I'm not going to spend a lot of time talking about this because CJ is going to take over pretty soon and spend a good portion of our time talking about this. But one of the things that our office is responsible for is ensuring that the state has a system of dispute resolution. And this is important because this is the opportunity, as I mentioned before, if any of those tenets of IDEA are not working, or you feel that they're not working within a school district or individually with your family or your student with a disability, we really do have a structure of processes that offer timely resolutions. And so we're going to review those pretty specifically today. But I think it's important to know that this system is in place as a checks and balance for all of us. Because again, we oversee these programs and there are times when we need to know that things aren't working out there so that we can adequately give those districts support for them. But furthermore, it's an opportunity for parents to have options to work through the disputes that may exist within the system. Another part of our responsibilities is in regard to data, and I mentioned Catherine, who's our data manager in our office, and we collect a lot of data around different indicators throughout the state, starting from early childhood up to transition. And we provide our OSEP, our Office of Special Education Programs, an annual report on all the data that we collect throughout the state. So, and then from that information, the federal government makes a state determination for our state as to how we're doing. And we use that to make district determinations on how the districts are doing. And that, again, is all in our state performance and annual performance report. So once we report that, we report on all the 17 indicators that have been written, or the 17 indicators that we collect data on. And we didn't go through the indicators specifically, but the data that we collect covers all of the aspects that we just talked about in general supervision. Again, the outcomes for students, our graduation rates, and many other indicators across the system. And so I know that's really a very general overview of the work that we do, and it's pretty expansive. But I think it's also important to note that we don't do this work alone and in isolation of others in our state. We work specifically with what we call our Special Education Advisory Committee, or our SEAC. This is a group comprised of parents, agency representatives, institutes of higher education across our state, as well as district level administrators and teachers. And the role of this committee is really to help us and guide our work, all that work that we talked about. So any reports that we are getting ready to submit, any initiatives that we are getting ready to put forward, we put in front of this group to really advise us on whether those are the right programs to help us meet the unmet needs of our students with disabilities across the state. And they also help us in deciding where we're going, as well as if there's the need to develop or implement any new policies around the coordination of services for children with disabilities. So it's really a group of people that come together to not only look at our work, but to support our work, endorse our work, and help us move in the directions that we need to go if there's something that we're not aware of. It really is a time for different groups of people to share information about what's happening across different service areas. The other group that we meet with on a regular basis is our Special Education Directors Association. This is comprised of the special education directors from each of the districts and our state public charter school authority. And we ensure that they know their responsibility to those tenets of general supervision, that they know what they're supposed to be doing in their districts to meet the state and federal regulations, and to really identify, again, issues that are happening that we can work together to address. And so, we are a small and mighty team. There's only a few of us in our office, but again, that's why we're so dependent on the external groups that we work with to ensure that they're guiding our work with us. And I should mention, which I didn't mention, that part of the Special Education Advisory Committee is a required seat is the Parent Information Center, also from the state of Nevada. So again, I know that's a lot of information to digest in a small amount of time, but we're going to give you more to digest. So CJ is going to go through the specifics of our dispute resolutions options. Again, we felt it was really important to focus on this so that parents and educators know what's available to them to ensure that all the services and needs of our children are being met across the state.
Okay, thanks, Julie. If you want to go to the next slide. So as Julie said, we really wanted to, when we were talking about planning for today, one of the things that we really want our constituents to be aware of in Nevada is our dispute resolution system and the different processes within it. So that if there is a need for you as a family member or a parent of a student with a disability to engage in one of these processes, you're aware that they exist. And also we have as you'll see, dispute resolution processes that any constituent can make use of and report or file a complaint through. So just sort of to set the sort of landscape in Nevada, we have approximately 62,000 students with disabilities. And every student who is eligible for special education services has an IEP. And each one of those students with an IEP is required to have at least one annual meeting per year. So and that's just the one annual that's required, right? Many of our students have multiple revision IEP meetings throughout the year. So, there could be anywhere from, 70 to 90 or 100,000 meetings a year across the state for students with disabilities. And when you think about all of those meetings that are held annually, there's often a lot of opportunity for disagreement within those meetings. So you can go to the next slide, Julie. So think about it, and you can type this in the chat. We're gonna look at in a little bit actually what our dispute resolution, like especially with our due process hearings, what topics actually come into our office in terms of due process filings and due process requests. But think about that for a minute, and as you're listening to me sort of go through the slides, feel free to type some ideas you have into the chat as what you think might be some areas of conflict as it relates to kids with disabilities. I'm already seeing some number of minutes for related services. Yeah, conflicts over accommodations. Yeah, go ahead, Julie. So one of the things we like to sort of start talking about is some of the associated costs when there's a dispute between a district or a school and a family related to an IEP. And those really fall under two categories, tangible cost as well as intangible costs. And you can see what those are on the screen. The tangible costs are things like attorney's fees and paying for expert witnesses, hearing transcripts. And then you have like time costs that are tangible, where you may have a staff member who has to be prepared for a deposition, has to leave the classroom to go to the deposition, and it takes away from the classroom and the students and the schools. And then you have these intangible costs like delayed service delivery to students. And if service delivery that is needed is delayed, it can hurt the achievement of the students. And it can damage those relationships, right, between schools and families. It damages trust and credibility, and parents may not want to be involved as readily if there's this dispute that's occurring or trust has been broken with the school or school district. Go ahead, Julie. And so one of the things, this is actually from the Office of Special Education Programs in one of their Dear Colleague letters from the United States Department of Education, where they talk about that they would really like to see public agencies, which in our case is typically school districts, really attempt to engage parents in informal processes for dispute resolution, as opposed to sort of going straight to these due process hearings, which can really drag out in terms of time and can potentially delay services to students. And that's really what sort of the end result of all these dispute resolution processes should be, is getting the appropriate services to students. Okay, Julie. And again, we encourage at the NDE parents and school districts to try to work together to resolve disagreements within their special education programs and for students with disabilities. But we know, right, there are times when you just can't come to those resolutions and you can't resolve a disagreement without some external help. And so that's why we have these dispute resolution options in place. And they're also required by federal law, which you'll see as we move forward. Good, Julie. And this actually, if you look up, and these actually link to the specific regulations under the federal IDEA law as it relates to dispute resolution. But if you were to click on any of these links, it would take you to the very specific IDEA language as it relates to these required dispute resolution processes. And so you'll see things in here like mediation and due process. And even things that we're required to do, like provide model forms for constituents for completing the process of entering into one of these disputes. Go ahead, Julie. So we at the Office of Inclusive Education actually ensure that these options are available. We make sure they're maintained within federal law, and we have evaluation processes for people who actually go through these dispute resolution processes. And each of our resolutions is offered in adherence to the IDEA and those requirements, but we also go beyond IDEA and we offer a broader continuum of resolution options as well that you'll sort of see as we go through these. We also provide technical assistance materials to the public, to parents. We have model forms, again, like I was talking about, where if you want to file a due process request, there's a model form for you to be able to do that, which makes it easier. We can talk parents or districts even through the process of filing. And while we maintain this system, I think it's also important to know it is an external system to us. Sorry for that. It's an external system for us where we pay a consulting attorney to sort of manage this system. We don't have any sort of direct interaction with the system in our office, and so we don't influence the system in any ways. It really is sort of an objective third-party system of resolving these disputes. And we offer technical assistance to LEAs, advocates. We provide ongoing training to our hearing review officers, our facilitators and mediators, and we track and analyze issues that are identified through this process. And just last year, we had a dispute over the Part C to B transition. That's the preschool to school age transition that we were able to identify through this process that needed a more sort of systemic, needed attendance to from our office in a sort of more systematic and systemic way. Next slide. And so IEP, so this is getting into sort of the dispute resolution options that we offer. IEP facilitation is the first one. This one is actually not required under IDEA, but essentially what this allows is in a district or a parent can request IEP facilitation, but that request must be agreed upon by both parties. So if a parent requests, the district would have to agree to participating in the facilitation and vice versa. But essentially what happens here is a trained facilitator who's impartial is assigned to the case or the filing, and they work with the IEP team to problem solve. And the end result for this process is really an IEP that's supported by all team members and that benefits the students. And this is one of our options that's totally at public expense. Go ahead, Julie. Some of the benefits of IEP facilitation is it really builds and improves relationships among the IEP team members and between parents and schools. It can be more cost effective. The typical cost for a facilitation to the state is between $500 and $1,000. The NDE provides the trained facilitators, and it's a typically less stressful. And again, in this process, there's no hearing officer, there's no attorneys. So the parties really maintain sort of agency over the process, which can really be empowering, right? And this is a process that really supports all parties in participating fully. Okay, next slide. And this is a question. What do you think? IEP facilitation, true or false? Is it one of our most underutilized dispute resolution options? And you can type that in the chat as well. And you can go ahead and go forward to Julie as they type. It's true, absolutely. The folks who are answering that are answering it correctly. We don't really see people utilize this enough, even though I think a lot of our disputes that do get filed in the office could be resolved through this process without going to some of our more formal processes. Okay. Mediation is the next one I'm going to talk about, and it's very similar to facilitation. Can be filed by a parent or a school district. A trained mediator is provided through our dispute resolution process. The difference here is that the final outcome of the mediation is a signed, legally enforceable written agreement. So where facilitation, we're really looking at just getting to that agreed upon IEP. With mediation, we actually get to a point where there is an enforceable, a legally enforceable written agreement between the two parties. And again, mediation is provided at public expense, and mediation is required through the IDEA. Go to the next one, Julie. And really, again, the role of the mediator is similar to that of the facilitator. They facilitate communication between the parties, create a safe environment, ensure sort of that there's, sort of respectful and understanding collaboration within the process. And the mediator can clarify points of disagreement, offer solutions or options, and they also assist in writing down the agreement that the two parties ultimately, hopefully, come to. Next slide. And then, benefits of mediation, again, it's sort of like the facilitation piece, right? Where the two parties sort of maintain agency over the process. This doesn't include attorneys or, hearing officers sort of handing down a decision like some of our other processes do. And it also can allow for disagreements to be resolved more quickly than some of our other dispute resolution items that have very sort of specific timelines that have to be followed. Next slide. This is the third process we're going to talk about. It's a state complaint. And this is a process that's used to communicate that a district has not followed the IDEA and to request an investigation. And this is our only dispute resolution process that can be initiated by anybody. So any constituent can initiate a state complaint. And so the outcome of the state complaint is a written decision that includes findings and conclusions. And it may include corrective actions for a district that are either student specific, or it might address like system-wide issues related to a failure to comply with the IDEA. There is a timeline for this one. A written decision has to be issued no later than 60 calendar days after the complaint, unless there's some extension to the timeline that's given. And there is also a statute of limitations on this one. So it has to be filed within 1 year of the date when the individual who's filing knew or should have known of the problem. And again, this is a process that is also provided at public expense. Next slide. Due process is really our sort of most formal process. It can only be initiated by a parent or a school district. And this process is used to resolve formal complaints regarding disagreements that are related to, and some of you guys identified some of these things as issues earlier. Identification as it relates to special education and disability, evaluation procedures, educational placement, or the provision of FAPE to the student. And again, the outcome of a due process is a written decision with findings of fact and conclusions of law that are legally binding. The timeline, there's a timeline for this process. A resolution meeting must take place within 15 calendar days of the filing of a due process complaint. And just so you know, a lot of the due processes that are filed, in fact, last year, I think there were 81 due process requests, and 72 were actually withdrawn or settled within this period where the resolution meeting takes place before going to a hearing. So most of these that get filed actually don't always make it to a full hearing. And for the resolution meeting, you can have up to 30 calendar days to work on a resolution prior to a formal hearing being initiated. A written decision must be issued within 45 calendar days from the end of the resolution period, unless a hearing officer grants a specific extension of the timeline. And that has to be at the request of both parties. Next one, Julie. There's the statute of limitations for a due process. It must be filed within 2 years of the date when the filing party knew or should have known of the problem. This is not at, and the due process is not at not at our public expense at the SCA level. In fact, the district in the case of a due process is responsible for all expenses related to the due process hearing itself. So this is specific to the hearing, and this can include the hearing officer, any interpreters are needed, transcription services, and each party does have to pay its own expense to put on its case. So the parent would be initially responsible for putting on its case. So that might include attorney's fees. It might include expert witnesses, to pay expert witnesses to come and talk. If the party prevails, so if like the parent prevails, they may actually be awarded through the hearing attorney's fees, but that's not guaranteed, right? And so we just like to make that point. And these decisions for a due process can be appealed. They can be appealed to the superintendent of public instruction, In this case, right now, that's Superintendent Joan Ebert for review by a state review officer. And a state review officer's decision can be appealed through state or federal court. And that's how, when you hear about, big special ed cases that make it all the way to the Supreme Court, and then there's actually been very few of those, but this would be how that process begins, through these appeals, right? There can be an expedited due process hearing in sort of very special cases. But those are only really related to when parents disagree about placement decisions for disciplinary removals, and when a parent disagrees with whether or not a student's behavior is related to a removal related to discipline. And this is called a manifestation determination. Okay. And the last one I'm going to talk about is a relatively new process. It's called a constituent concern inspection, and it's new as of 2017. And this is really a state-specific process. And basically, any constituent with knowledge here of an issue regarding compliance with special ed law and regulations can file a constituent concern, or can file for a constituent concern inspection. And this could be something that affects either a single student or multiple students. If the NDE finds good cause to investigate a filing, we must conclude the inspection of the provider within 30 days. And within 30 days of the completion of the inspection and finding of non-compliance, if the provider, like the district, is non-compliant, the NDE will meet with the provider to determine the most efficient and expeditious way to sort of correct what needs to be corrected. The one thing I want to point out about this process is the way it's regulated. The constituent that files this type of complaint will never really know about the result or the end result of the complaint, what happened, right? And that's because of the way that the regulations are written. And that's not true of the other processes that we went through. Next slide, Julie. And these are sort of the big trends within some of our processes. You can see state complaints. Some of the big trends are in terms of filings are related to IEP implementation, parent participation, and student placement. Due process, it's student placement, evaluation problems, or IEP implementation. And then mediation is IEP implementation and IEP accommodations and services. And again, some of those were you guys identified in the chat. And for due processes, and so that, remember, this is one of our more formal processes that can go to hearing. For fiscal year 2022, these are sort of the more specific issues that we saw within our filings. And so you can see IEP implementation and placement determinations are our two most frequently filed issues. You have IEP services that follow that up, evaluation issues. BIP is behavior intervention plans. And then you can kind of see it tapers off. And really, these on the far right are kind of just sort of one-off filings. So, the 1-to-1 transition services, we didn't see last year repeats of those. Julie? The last thing I want to sort of leave you with is at the bottom is a link to our webpage that provides links for information and a technical assistance models and forms for filing all of these. And you can even see at the bottom, we do post the reports for our state complaint and due process hearings, where you can actually go and look at some of the more specific details of these hearing decisions and what the outcome was, as well as any of those hearings that went to review. And so we try to be incredibly transparent with this. When we get calls about disputes in school districts in our office, we don't get off the phone with parents or families without letting them know about these processes. And our districts are all made aware of this as well through some of our consultation with them. And I think that, the future in terms of this, right now, there's a filing process through sort of email and fax, but we are moving to a sort of centralized digital system that'll be called Nevada Access. That will make it a lot easier for these filings to occur and a lot easier for our office to track and report on them and provide even more transparency with our state. And we're looking for that to come online March of 2023. Okay. And so that's kind of it for us in terms of our presentation materials. If you have questions, I think we have maybe maybe 1 minute to answer them. So we kind of pushed it to right to the end. But we're here. If you go to the next slide, Julie, it also has our email addresses, Julie and I. So if you have questions, you can also contact us through either of these emails, and we can answer them for you. Or even if you just have any questions about, some of these processes that we've gone over today, because we really want families and we want school districts to be aware that these exist and sort of the nature and character of the work that we do at the department.
I know that was a lot of information to take in, and so we really feel that it's important that that the Department of Education and our Office of Inclusive Education is really to make sure that the system is working for everyone. And when the system isn't working, that that there's a process to help with that too. And it's really important to us because it gives us feedback as to what's happening in the system. And it helps us make decisions about the work that we need to do and prioritize to ensure that the system is working for everyone. So that was sort of the goal of our presentation today. I noticed I was sort of breezing through the chat, and I noticed that somebody said they'd never heard of IEP facilitation, and we know that, and that is part of the reason why it's our most underutilized. And so we like to share this information, even though it seems to be the wrong focus if we focus on the disputes, but it's very important that everybody knows this information and knows it's available to them. I think somebody else asked whether or not some of our policies and procedures in regard to compliance and other issues are on our website. And I will say that we are updating our website, and that come next spring, it should absolutely involve everything that anyone needs to know about our work, our policies and procedures, and access to the tools and resources that are needed for our educators and families. And if there's any other specific questions, I don't know, CJ, if you're looking at the chat.
I just saw one about, some of the challenges in our system related to, teachers, and not having enough teachers. I think they specifically talked about Clark County and students being taught by substitutes. And that's certainly something we're aware of at the department. In fact, Julie and I are going to a teacher recruitment and retention conference here in December. It's just I was this past summer, I was actually at a summit, legislative summit in Washington, D.C. And one of the big topics and one of the things that we were advocating with the federal legislature about is this issue related to teacher shortages. We definitely know it's a problem, and certainly it can harm our kids with disabilities when they don't have access to a fully qualified teacher, for sure.
I will just end by letting everybody know also, we talked about those stakeholder groups, and I want to make sure that everybody knows that we do have some open seats on our Special Education Advisory Committee. So if you were interested in knowing what those seats were, and if you would meet the criteria for one of those seats and want to participate in that group, you can contact our office as well. We are always actively recruiting members for that team.
So thank you so much to CJ and Julie for presenting today, and everybody for attending this breakout session.